Writing in 1629 of the wreck of the Batavia off the coast of Western Australia, the Dutch navigator François Pelser wrote of his encounter with a strange creature. Besides, we found in these islands large numbers of a species of cats, which are very strange creatures. They are about the size of a hare, their head resembling that of a civet cat. The forepaws are very short, about the length of a finger, on which the animal has 5 small nails or fingers resembling a monkey's forepaw. Its 2 hind legs, on the contrary, are upwards of half an ell in length, and it walks on these only, on the flat of the heavy part of the leg. 150 years later, on the 24th of June 1770, Captain James Cook recorded in his journal on board the Endeavour, "I saw myself this morning a little way from the ship, one of the animals before spoken of. It was a light mouse colour and the size of a greyhound, and shaped in every respect like one, with a long tail which it carried like a greyhound. In short, I would have taken it for a wild dog, but for its walking or running, in which it jumped, like a hare or deer." One can sense in these short passages the wonder and surprise of these early European visitors to our land of this creature quite unlike any that they had ever seen before. As Sir Joseph Banks, the famous botanist and naturalist who accompanied Cook, was a few days later to record, to compare it to any European animal would be impossible, as it has not the least resemblance of anyone I have seen. These creatures, known as kangaroos, wallabies, and like members of the marsupial family, had long had a special spiritual and cultural significance to our land's traditional owners, and were soon to capture the imagination of Europe. However, Cowley and Huber, in their fascinating account of early European images of Australian animals, from which I've drawn, observed that it was not long before the animals themselves were exported. By 1792, 2 kangaroos had been established in the Royal Gardens at Richmond, and by 1802, during a brief lull in the Anglo-French conflict, Sir Joseph Banks was to arrange for a pair to be supplied to France, who were established in the Jardin des Plantes. Export of native fauna is regulated today under Part 13A of the Environmental Protection and Biodiversity Conservation Act of the Commonwealth. And it is through these means, among others, that the Commonwealth seeks to regulate not only the sustainability of commercial trade in native fauna such as kangaroos, undertaken pursuant to state law, but also the welfare and humanity of the means by which these animals are taken. And it's upon that scheme, and in particular upon accountability for the exercise of powers under that scheme, through merits and judicial review, that I want to focus. As Keeley has outlined, the essential regulatory framework for the commercial culling of kangaroos involves an interplay between state and federal laws. The starting point is state law, and I'm going to take New South Wales as my illustration. Kangaroos, and indeed all native fauna, are protected fauna under the National Parks and Wildlife Act of New South Wales. That Act provides a very basic regime for the issue of commercial fauna harvesters licences by the Director General to harm fauna, which includes hunting and shooting, for the purposes of sale. Registered carcass chillers only must be used, and under the regulations, the Director General may issue tags to be affixed to the carcasses in compliance with conditions on licences, thereby providing mechanisms whereby compliance with licence conditions can be monitored. The limitations upon the issue of such licences otherwise reflect only environmental concerns, which is, of course, the concern of the Act. with licences not extending to national parks, conservation reserves and the like, unless the terms of the licence otherwise provide, nor may they be issued with respect to threatened species. The State Act therefore deals with the kangaroo cull on a licence-by-licence basis. It vests a broad discretion in the Director-General to issue licences and impose conditions subject only to the objects of the Act, being nature conservation. That statutory system provides no transparency, no requirement for public consultation, and no public accountability, otherwise than through the audit requirements of the Act and constitutional principles of responsible government by which ministers are accountable to the Parliament. Animal welfare concerns can be addressed in turn only on a case-by-case basis through breach of conditions on licences and prosecutions for animal cruelty under state law. That system contains effectively no recognition of the legitimacy of the public interest in questions such as whether the cull should take place, its extent, and how it should be undertaken. It is a statutory framework that is ill-suited for a cull of the size undertaken with respect to kangaroos in the state, and it stands in stark contrast, for example, to the statutory scheme under the Environmental Planning and Assessment Act, which provides for public consultation, full merits review of decisions with open standing to any member of the public, and judicial review of the legality of decisions made. But that, of course, is not the complete picture as to the position at state law. The cull is in fact carried out pursuant to a plan prepared by the Office of Environment and Heritage, currently for the period 2012 to 2016. Its primary goal is to ensure that the commercial harvest of kangaroos within the state is ecologically sustainable. However, as the plan is not produced pursuant to a requirement under state law, with prescribed legal consequences, it is difficult to conceive of a means by which its validity could be challenged. It does not have a readily identifiable legal status under state law. The plan provides that harvesters' licences issued under the National Parks and Wildlife Act are subject to certain conditions. These include that all kangaroos must be shot in accordance with the current National Code of Practice for the humane shooting of kangaroos and wallabies for commercial purposes. In so providing, the plan has been determined to satisfy one of a number of requirements under the Environmental Protection and Conservation Biodiversity Act of the Commonwealth, which one of the recommendations of the Hawke Review one hopes is taken up, is that name, which is too much of a mouthful, is changed. What opportunities then might exist under the Commonwealth Act for the review of the Commonwealth's decision to approve the plan of management? I'll start with a few words about how the Commonwealth scheme operates. The Commonwealth has no specific head of power to make laws with respect to animal welfare and protection. And to the extent that it ventures on the field, it is reliant on a miscellany of power on subject matter, such as external affairs, quarantine, and the corporation's power. Of primary relevance here, however, is Section 51(1) of the Constitution, conferring power on the Commonwealth to make laws with respect to trade and commerce with other countries and among the states. Relying on that head of power, the Commonwealth has enacted provisions under Part 13A of what I'll call now the EPBC Act, regulating export of native fauna that reach back beyond the point of export to the circumstances in which animals potentially destined for export are taken. Under this regime, all kangaroos may only be exported for commercial purposes under a permit, where their export would be in accordance with an improved wildlife trade management plan declared by the Minister. The Minister's power to issue such a declaration is subject to preconditions. These include a process of public consultation, an assessment of the impacts on the environment, the results of which must be taken into account by the Minister. The Minister must also be satisfied, among other things, that the plan is consistent with the object of promoting the humane treatment of wildlife, and that compliance and enforcement measures specified in the plan are likely to be effective in preventing animals taken in breach of the plan from being traded or exported. The regulations go further and require that the killing of the animal must be done in a way that is generally accepted to minimise pain and suffering. It is presumably the requirement in the state plan for compliance with the National Code for the humane shooting of kangaroos, which was the basis on which the Minister must have held that these criteria were satisfied. That National Code was produced in turn by a working group established by the National Natural Resource Management Ministerial Council after public consultation to set what is described as an achievable standard of humane conduct and the minimum required of persons shooting kangaroos and wallabies. And it exists alongside existing state and territory animal welfare legislation. However, the National Code, again, is not produced pursuant to statutory power, but in the exercise of pure executive power and has no independent legal status. That leaves the declaration made by the Commonwealth Minister of approved wildlife management plans to be considered. Until recently, such declarations were open under the EPBC Act to a full merits review by the Administrative Appeals Tribunal. The Tribunal could exercise all of the powers, discretions vested in the Minister in order to reach the correct or preferable decision. There were a number of applications for review in fact made, including the last by the Wildlife Protection Association of Australia in 2007, in relation to the approval of the New South Wales Commercial Kangaroo Harvest Management Plan 2007 to 2011, which contemplated the culling of in the order of 1 million kangaroos each year. While those challenges were not successful, they provided a transparent and public process whereby evidence could be led and tested and a determination made by an independent tribunal on the merits, with reasons. There was a full accountability for the decision made. A robust merits review system also has the long-term objective of improving the quality and consistency of decisions by government. However, in 2006, the Act was amended so that decisions made by the Minister personally on the grant of import and export permits and on the wildlife trade management plans could no longer be subject to review by the Administrative Appeals Tribunal. A recommendation in the recent Hawke Review that merits review be reinstated was rejected by the government in its response. The reasons given were that such decisions involve the consideration of competing factors to determine what is in the national interest that are appropriately made by an elected representative. However, as the Administrative Review Council has said, and I should explain I am a member of that statutory body, the identity of the decision maker is not relevant to a consideration of the appropriateness of merits review. What is relevant is the character of the decision that is being made. And in this regard, it is notable that the several matters specified in the EPBC Act, which must be taken into account by the Minister in approving a wildlife management plan, do not include, at least expressly, the national interest or any equivalent criterion. Furthermore, Dr. Hawke found in his report that there is no evidence that the merits review powers of the AAT were abused prior to the 2006 amendments. The number of cases, he said, brought to the AAT was small and typically involved significant issues. So the one avenue left is judicial review of the legality of the legislative instrument constituting the declaration. That avenue of review is constitutionally guaranteed and can be effective, particularly where, as here, the process that must be undertaken in accordance with processes specified in the Act and the power exercised having regard to specified and mandatory considerations. But it remains a much narrower mechanism for review. It is not for the court to determine whether the decision made is the correct or preferable one, but only whether it was made within lawful boundaries. How well then do we protect the proud animal that once captivated the imagination of a people and a nation? Have we lost the appreciation and wonder that those from Europe felt upon first encountering these creatures in a strange land, and perhaps still hold? A basic licensing system of the kind contained in the state law can scarcely be regarded as an appropriate legal mechanism by which decisions of such significance are made. By reason of the Commonwealth regime for the regulation of exports, the state is required to develop a management plan which must be open to public consultation and meet certain standards, including as to animal welfare. But even then, the decision itself is not transparent and the mechanisms for holding the Minister accountable are limited. There remains much room for improvement when assessed against the fundamental administrative law values of fairness, transparency and accountability, and to promote the rule of law. Thank you.